They built 96 houses on my land. Foundations poured, roofs up, families already picking out curtains for windows that shouldn't exist. I watched it happen. I let it happen. Every single day, while the HOA congratulated themselves on the fastest development in county history, I sat on paperwork that would turn their finished neighborhood into a 96-home crime scene. They thought silence meant surrender. Didn't. It meant I was waiting for the one moment they couldn't undo, rebuild, or apologize their way out of. By the time they realized whose land they'd built on, it was already too late to matter. So why did I wait? And what did I know that they didn't? My name doesn't matter as much as the land does. So let's start there. 40 acres, sitting on the northern edge of what used to be my grandfather's cattle ranch. He bought it in 1968 for less than the price of a truck. When he passed, it came to my father. When my father passed, it came to me. I never touched it. I didn't farm it. I didn't build on it. I paid the taxes every year, kept the deed in a fireproof box in my closet, and let the land sit there, quiet, wild, mine. Some people inherit jewelry. Some inherit debt. I inherited 40 acres of scrub oak and silence, and honestly, the silence was worth more to me than anything I could have sold it for. I lived 2 miles from that land, in a modest 3-bedroom house I bought with my wife back when property values still made sense. We raised our kids there. Nothing special about the house. A decent kitchen, a yard the dog tears up every spring, a garage that never quite fits both cars. It's the kind of home nobody notices, which is exactly how I like it. Our neighborhood is calm, or at least it used to be. Manicured lawns, recycling bins that all match. The kind of place where the biggest scandal for years was somebody parking a boat in their driveway for 6 weeks straight. We have an HOA, like most developments built in the last 20 years. Mostly, it stayed in its lane. Mowing complaints, paint color approvals, the occasional passive-aggressive letter about holiday decorations staying up too long into January. Paid my dues. I nodded at board meetings I barely listened to. I signed off on things without reading every line, because who has time to read 50 pages about fence heights and mailbox styles? I trusted the system to stay small, stay boring, stay in its own boundaries. That trust was my first mistake. See, about 3 years ago, a development company started buying up land north of our neighborhood. Big plans, aerial renderings, a master-planned community with walking trails, a clubhouse, and, the number that should have made me pay closer attention, 96 new homes. I remember seeing the flyer stapled to a telephone pole near the entrance of our subdivision. Bright colors, a smiling family on a porch that didn't exist yet. I remember thinking, good for them, glad someone's expanding the tax base and going back to mowing my lawn. What I didn't know, what nobody bothered to tell me, was that the surveyors doing the boundary work for that development had made an assumption, a convenient one that saved the development company thousands of dollars in rerouting costs, re-engineering costs, environmental assessment costs. They assumed my 40 acres belonged to the parcel they were building on, not stole it outright. Nothing that dramatic, not at first, just folded it in, absorbed it into their site plans like it had always been theirs. The kind of mistake that looks like an accident until you understand exactly how much money was riding on nobody noticing, and nobody did notice. Not for a long time, because here's the thing about inherited land you never touch. You stop watching it. You stop driving past it. It becomes a line item on a tax bill instead of a place. I hadn't set foot on those 40 acres in over a year when the first construction trucks rolled in. By the time I did find out, they weren't breaking ground. They were already 3 months into pouring foundations, and the HOA, my HOA, the one I'd trusted with fence height opinions and paint swatches, was thrilled. New development meant new dues-paying residents down the line, once the developments merged jurisdictions. New value on everyone's property. New bragging rights at the next town hall meeting. Nobody was going to ask questions about a boundary line when the answer might slow down 96 houses worth of profit. Nobody. Except me, because I had something they didn't know I had. Something sitting in that fireproof box in my closet, next to a deed with a survey stamp from 1968, decades before their master-planned community existed, even as an idea in someone's spreadsheet. I could have stopped them immediately. One phone call, one certified letter, one meeting with a lawyer, and the bulldozers would have stopped that same week. I didn't make that call. Not yet. The first sign that something was wrong didn't come from a lawyer or a surveyor. It came from my mailbox, a letter, HOA letterhead, informing me that my property, my actual house, the one I'd lived in for 15 years, was out of compliance with the new neighborhood unification standards recently adopted by the board. Apparently, once the northern development was finished, our two communities would be merging under one HOA umbrella. Same rules, same fees, same architectural review board. I hadn't voted on that. Nobody had asked me. The letter cited my fence, 6 feet, cedar, built the year my son was born, as inconsistent with the aesthetic, direction of the unified community. I had 30 days to bring it into compliance, or face a fine of $200 a week until, corrected, $200 a week, for a fence that had stood without complaint for over a decade. I called the HOA office expecting a mistake, a misunderstanding, something I could clear up with one conversation. Instead, I got a property manager reading from a script, telling me the new standards applied to all homes within the expanded jurisdiction, and that my grandfather clause eligibility would be reviewed by the board at their discretion. At their discretion. As if fairness was a favor they might grant me if I behaved, I should have made the phone call then. The one about the deed. But pride is a strange thing. I told myself I'd handle this small fight first. Prove I wasn't someone to push around and deal with the land situation on my own terms, my own timeline. That decision cost me more than I expected, because the fence letter was just the opening move. 2 weeks later, a second letter arrived citing my detached garage as non-conforming to unified setback requirements. The garage my father built himself, 22 years before the HOA even existed. Another fine. Another 30-day window. Another vague reference to a board that met behind closed doors and communicated only through certified mail. I started attending the HOA meetings again. Really attending, not just nodding along. And what I saw changed something in me. The board president, a man who'd moved into the neighborhood barely 3 years earlier, ran meetings like a corporate boardroom, dismissing questions from longtime residents with a practiced kind of condescension. Every objection was met with the same phrase, "The covenants are the covenants," as if that answered anything. As if 40-year-old handshake agreements between neighbors were the same as a 50-page legal document nobody remembered signing in full. I watched an elderly widow, a woman who'd lived in the neighborhood since before pavement replaced the gravel roads, get fined $300 for a wheelchair ramp built for her late husband. Non-conforming structure, they called it. Nobody on that board had the decency to ask why it was there in the first place. I watched a young couple get a violation, notice for a basketball hoop in their own driveway, a hoop their 8-year-old used every single day. After school, because it violated line-of-sight standards, nobody could actually define when pressed, and every single time, the justification circled back to the same thing, the northern development, the 96 homes, the idea that our entire neighborhood needed to look, feel, and comply like a brand-new buttoned-up subdivision, because that's what would justify the property value jump everyone on that board was banking on. They weren't protecting community standards. They were staging a neighborhood for a sale none of us agreed to be part of. My fines kept stacking. $600, then $1,000, then $1,200, once they added a late compliance penalty I hadn't been told existed until it appeared on a bill. I fought back the only way I knew how at first: paperwork, phone calls, polite requests for documentation, meeting minutes, board bylaws, anything that would show me exactly what authority they thought they had. Every request was met with delays, missing documents, files that would be located and forwarded and never were. Then came the letter that changed everything, a letter informing me that due to unresolved compliance issues, a lien was being placed on my property, my home, the one thing that had nothing to do with any development, any fence, any garage built before most of that board could legally drive. I remember sitting at my kitchen table with that letter in my hands, my wife across from me, both of us just staring at it like it might rearrange itself into something less terrifying if we looked long enough. That was the moment I stopped being patient. I drove out to my 40 acres for the first time in over a year. I wasn't prepared for what I saw: foundations, dozens of them poured and cured, stretching across land I hadn't given anyone permission to touch. Framing crews were already up on some lots, hammering in the early morning light like this was the most normal thing in the world. A sales trailer sat near the entrance with a banner reading, "Now selling. Founders Collection from the 400s. Founders Collection." Built on land they didn't own. I stood at the edge of what used to be my grandfather's ranch and watched strangers building futures on a foundation of a mistake nobody had corrected. A mistake that, conveniently, made everyone involved richer. Except me. I pulled out my phone and took pictures. Dozens of them. Foundations, framing, the sales trailer, the banner, the flags marking utility lines that ran straight through what should have been my property. I didn't say a word to anyone on site. I didn't need to. Not yet, because now I understood something the HOA board didn't. They were about to merge my current neighborhood's governance with a development built entirely on stolen land. Every fine they'd charged me, every lien they'd threatened, every ounce of petty power they'd exercised over fence, heights, and basketball hoops, all of it was about to collide with a legal problem so large it would make wheelchair ramp violations look like a joke. I drove home that night and finally opened the fireproof box in my closet. The deed was exactly where I remembered. 1968 survey stamp, my grandfather's signature, a legal description that matched parcel for parcel, acre for acre, with the land currently being turned into 96 half-built houses. I made 2 phone calls that night. The first was to a real estate attorney who specialized in boundary disputes and adverse possession claims, someone recommended by a friend who'd dealt with a similar mess years earlier, though nothing on this scale. The second call, I didn't make to a lawyer. I made it to nobody yet. All because the real decision, the one that would define everything that happened next, wasn't about who to call. It was about when the attorney's advice was clear. I could file an injunction immediately, stop construction within days, force the HOA and the development company into a legal reckoning before another foundation got poured. I didn't do that either. Instead, I asked her a single question that made her go quiet on the other end of the line. "What happens," I asked, "if I let them finish?" The attorney's silence lasted maybe 10 seconds. It felt like 10 minutes. Then she asked me the only question that mattered. "You want to let them finish building?" I told her yes. All 96 homes. Every foundation, every roof, every closing sale to every family who had no idea they were buying into a nightmare. I wanted the development company financially committed beyond the point of no return. I wanted the HOA celebrating their unified community, their rising property values, their expanded jurisdiction, right up until the moment it all became legally radioactive. She warned me this wasn't standard practice. Most attorneys would tell you to stop the bleeding immediately, file the injunction, protect your interests the second you have proof. Waiting meant risk. It meant emotional distance from the panic and anger that would come once I revealed what I knew. But I'd spent a year absorbing petty fines for a fence in a garage that predated the HOA itself. I'd watched an elderly widow get punished for a wheelchair ramp. I'd read a lien notice threatening the home my kids grew up in, over compliance issues manufactured to justify a merger nobody consented to. I wanted them to feel exactly what powerlessness felt like, on a scale they couldn't find their way out of. So we waited. 11 months. I kept paying my fines, teeth gritted, documenting every letter, every threat, every certified notice, building a paper trail that would matter later. I drove out to the 40 acres every few weeks, always alone, always quiet, watching foundations become frames, frames become houses. Houses become a fully realized neighborhood with sod lawns and mailbox clusters and a welcome sign that read, Founders Collection, a legacy community. A legacy, built on land that was never theirs to build on. By month 11, all 96 homes were complete. Closings had happened. Families had moved in. Actual people with actual mortgages. Unpacking actual boxes into houses built on a foundation of a mistake nobody corrected because correcting it would have cost the development company millions in rerouting, re-permitting, re-engineering. And that's when the HOA sent the letter that sealed everything. Formal notice, the unification agreement, was finalized. Our original neighborhood and the new 96-home development were now one single HOA. One board, one set of covenants, retroactively applied to every property, including mine. Along with the notice came a final demand. Pay the accumulated fines, now sitting at just over $4,000, or face foreclosure proceedings initiated by the HOA's lien, foreclosure, over a fence and a garage older than half the board members combined. That same week, I filed, not an injunction. Something far more devastating, a quiet title action, backed by a legal team that had spent 11 months quietly building the strongest possible case, including certified surveys, historical deed records, tax payment history going back to 1968, and, most damning of all, internal development company emails obtained through discovery showing that a junior surveyor had flagged the boundary discrepancy nearly 2 years earlier and been told, in writing, to proceed with current site plans, reroute if the issue surfaces later. They knew. Before a single foundation was poured, they knew. The lawsuit named the development company, the HOA board collectively, and the board president personally, given his direct involvement in approving the fast-tracked unification agreement that financially depended on the development's completion. The hearing was public record, and word travels fast in small communities. By the time the case reached the courtroom, half the original neighborhood showed up. So did a local news reporter who'd caught wind of the 96-home boundary dispute from a court filing clerk. I sat in that courtroom and watched the HOA's attorney try to argue adverse possession, claiming the development company had occupied and improved the land openly and continuously, for long enough to claim ownership regardless of the original deed. My attorney stood up, placed the 1968 survey on the projector screen beside the development's current site plan, and let the overlay speak for itself. 40 acres matching parcel for parcel. Then she played the internal email. Proceed with current site plans. Reroute if the issue surfaces later. The courtroom went silent in that particular way that only happens when everyone simultaneously understands exactly how bad something is about to get. The judge asked the development company's counsel directly whether they had known about the boundary discrepancy prior to construction. There was a long pause, too long. The kind of pause that answers the question all by itself. Then came the moment I'd waited 11 months for. The judge ruled from the bench that the quiet title action would proceed in my favor, pending final documentation review, effectively confirming what the deed had said all along. The land was mine, had always been mine, and 96 homes were sitting on a legal foundation that no longer existed. The HOA board president, the man who'd spent years dismissing wheelchair ramps and basketball, hoops with a shrug, and the covenants are the covenants, sat frozen at the defense table while a local reporter typed furiously in the back row. Outside the courthouse, cameras caught him saying no comment 4 times in a row while walking briskly to his car. But the ruling wasn't the end. It was the detonator. Because now came the question nobody in that courtroom had fully processed yet. the question that would define the next several months for 96 families, one development company, and an HOA board about to learn exactly what it costs to build an empire on land you were told, in writing, might not be yours. What happens to 96 homes when the ground beneath them legally belongs to someone else? The question hung over that courthouse for exactly 43 days. That's how long it took for the mediated settlement to take shape. 43 days of negotiations I wasn't in the room for, but whose outcome would define the rest of my life, and the lives of 96 families who'd done nothing wrong except trust the wrong sales brochure. Here's what I want you to understand before I tell you how it ended. I never wanted to take someone's home. Not really. My fight was never with the families who'd unpacked boxes into houses with my grandfather's land underneath them. My fight was with the people who knew about the boundary problem before a single nail was hammered, and built anyway, betting that nobody would ever check. So when my attorney came to me with the development company's settlement offer, I already knew what I wanted the outcome to look like. The company couldn't undo 96 completed homes. Nobody realistically expected demolition, and frankly, neither did I. What the ruling gave me was leverage. Real, undeniable, legally confirmed leverage. And leverage, used carefully, can rebuild things instead of just tearing them down. The settlement worked like this. The development company paid a substantial retroactive land value settlement, calculated not at the original raw acreage price, but at current developed value, the value 40 acres carries once it has 96 finished homes sitting on it. That number was not small. It was, in fact, the kind of number that changes a family's entire financial trajectory for generations. In exchange, I agreed to a negotiated transfer of the underlying land rights to the homeowner's properties, cleared and finalized, so that every single family who'd bought a house in that development could keep their home with a fully clean, fully legal title. Not because the development company suddenly grew a conscience, because the settlement made it clear that continuing to fight would cost them exponentially more in litigation, bad press, and a title insurance nightmare that would have made every single closing in that neighborhood legally poisonous for years. I want to be clear about something. Those 96 families never knew, going into their closings, that the ground beneath them was in dispute. They were victims of the same disregard I was, just a different flavor of it. Punishing them for a company's decision never sat right with me, and it still doesn't. The satisfaction I wanted was never about strangers losing their homes. It was about the people who knew and built anyway, finally facing a consequence proportional to what they'd done, and that consequence landed hardest, and most publicly, on the HOA. Because here's what most people didn't expect. The HOA board, the one that fined an elderly widow for a wheelchair ramp, the one that threatened my home with foreclosure over a fence built before their organization existed, had tied their entire unification agreement to the assumption that the development would proceed exactly as planned. Once the court confirmed the land dispute and the settlement became public record, that unification agreement collapsed. Legally, procedurally, and financially. The merger that would have brought 96 new dues-paying households under the original HOA's control never happened, which meant every projection the board had used to justify their aggressive new neighborhood unification standards evaporated overnight. No merger, no expanded jurisdiction, no justification for fining longtime residents into compliance with a unified aesthetic that was never going to unify anything. At the next HOA meeting, the first one held after the ruling became public, I walked in for the first time in months, not to fight, but to watch. The board president, the same man who'd once told a room full of neighbors, "The covenants are the covenants," like it was scripture, spent that meeting fielding questions he had no good answers for. Why were fines issued for structures older than the HOA? Why a wheelchair ramp was ever considered a violation? Why nobody disclosed the pending unification agreement's dependency on a development now legally compromised? He resigned 2 weeks later, quietly through a letter posted on the community bulletin board, citing personal reasons. Everyone in that neighborhood knew what the personal reason actually was. The fines against me were dropped, retroactively, along with every fine issued during that 18-month period against other residents for similarly petty, similarly manufactured violations. The widow got her wheelchair ramp fine refunded, with a formal apology letter that arrived roughly 2 years too late to matter to her the way it should have. But mattered anyways for my 40 acres, or what remained of them once the homeowner land rights transfer was finalized. The settlement money let me do something I hadn't expected to be able to do. I paid off my own home outright. I set money aside for my kids' education, money that didn't exist as a real possibility 18 months earlier. And I kept a small remaining parcel at the edge of what used to be my grandfather's ranch, undeveloped exactly the way he would have wanted it. No houses, no HOA, no covenants, just land, quiet again, the way it was supposed to be before anyone decided it was theirs for the taking. I still drive past that development sometimes. 96 homes, sod lawns grown in now, basketball hoops in driveways, kids riding bikes down streets that didn't exist 3 years ago. Those families have no idea how close they came to losing everything over a decision made in a boardroom. By people who assumed nobody was paying attention to 40 quiet acres nobody had walked in over a year. I don't regret waiting 11 months. I know some people would have filed that injunction the day they found the discrepancy, stopped construction immediately, avoided the emotional toll of watching strangers build lives on ground that legally wasn't theirs yet. Maybe that's the smarter move on paper. But there's a difference between stopping something and making the people responsible understand exactly what they did, in front of everyone with no way to spin it into a footnote. Power. The kind the HOA board wielded over fence heights and wheelchair ramps and basketball hoops, only exists as long as nobody with more leverage decides to push back. They mistook my silence for weakness for over a year. They fined me, threatened my home, dismissed my questions, all while sitting on a piece of land they never once thought to double-check. So here's what I keep coming back to, and maybe you will too. How many HOA boards out there are making the same bet right now, betting that the quiet homeowner in the corner lot, the one who doesn't come to meetings, the one who just pays the fine and moves on, will never be the one holding the one piece of paper that changes everything? Because I was that quiet homeowner, right up until I wasn't.